Hello and welcome to lecture 2 for topic 1. And in this lecture, we're going to look at the informal criminal justice process. Okay, so in the last lecture, we looked at the formal criminal justice system. And as you recall, the formal criminal justice system sees the criminal justice process as an assembly line where offenders go through each step of the process. But as we know that this rarely happens. And in fact, as we discussed in the last lecture, there's more of a funneling effect or a winnowing effect that happens. But there are many crimes that are committed, and about half of those people are where the crimes are reported to the police. But then identifying who the perpetrator is and charging that individual and actually getting them through all of those steps, that rarely happens. And so in this lecture, we're going to talk about why. What are the factors that contribute to the criminal justice funnel? And so you're going to be learning about the Courtroom Workgroup in this lecture and the so-called criminal justice wedding cake. Both of these are factors that contribute to the criminal justice funnel. So first, let's describe the funnel, and then we'll go in and we'll talk about how the work group and the wedding cake contribute to the funneling in the criminal justice system. So this diagram shows the criminal justice funnel. And the criminal justice funnel is based on research by Thomas Cohen and Tracy Kicklecon that they did in 2006. And what they did is they looked at the 75 most populous counties in the United States, and they basically followed what happened to the felony defendants within that population of those 75 most populous counties. And then, so this is a funnel that illustrates their findings from their research. So they said of the 1,000 felonies that are committed in the United States, half of them are never reported to the police. And so of the 1,000, and let me put my magic pen on here so we can see it a little bit better. Of the 1,000, 500 are never reported to the police. About only half are. And of the half that are of those felonies that are reported to police, only 100 of those crimes we find a person to arrest. 400 of those crimes, we never find anybody to arrest for that crime. In other words, 400 of the 500 are never cleared. So you have 100 people who are actually arrested for that crime. Of those 100, 35 are juveniles, and they go into the juvenile system. And we're not going to be taking a look at that. Juveniles have a separate criminal justice system. But 65 are subject to adult prosecution. Of the 65, and so this is where the prosecutorial stage begins. Of the 65, the prosecutor decides to charge 40 of those people with a crime. Remember, we talked about the concept of nolli prosequi. That's when the prosecutor decides not to pursue a case. So of the 65, 25 of them, they are never charged with a crime. Of the 40 that are charged with a crime, 10 of them jump bail, and so they just disappear and can't be found. Of the 30 who go to trial, the vast majority of those people plead guilty, okay? So they might initially plead not guilty, but then they engage in a plea bargaining, we talked about in the last lecture, and they decide to plead guilty to the charges. Only 3 decide to actually go to a trial, and 2 of those are found guilty, and 1 of them are acquitted of the crime. So of the 30, 29 are either plead guilty or are found guilty. Of the 29, 20 of those individuals will be sentenced to some form of incarceration, and 9 will be sentenced to probation, a non-confinement punishment, okay? And so starting with 1,000 felonies, 20 at the end of the funnel for the adult side are ultimately incarcerated. And as we know, many don't go through all the steps. Some people are never arrested. Some crimes are never reported to the police. Some are not charged. And so we really see that funneling effect. Now, you might be asking yourself, well, how do we know that a crime has been committed if it hasn't been reported to the police? Well, one of the things we're going to be learning about in Chapter 2 is the tools that we use to measure crime. And there's 2 different main ways of doing that. One way of measuring the amount of crime in the United States is to look at how many crimes have been reported to the police. We have another way of measuring crime too, where we ask people whether they've been a victim of crime. And so you could be a victim of crime and never report it to the police. And so that's how we know that there are many more crimes that are committed in the United States, because it's based on what victims tell us. And we don't just rely on reports to the police alone. So that's the criminal justice funnel. Let's take a look. On the next slide, let's think critically about the criminal justice funnel. Okay, so let's think critically about the criminal justice funnel. You'll see that over the course of the semester that sometimes when I introduce a concept in lecture, I'll put a slide that gets us to sort of think critically about that concept. And this is one of those instances. And it should also serve as sort of a hint for what is going to be appearing on upcoming exams. Because, for example, there will be a question on the midterm exam that gets you to think critically about the criminal justice funnel and asks you in what ways the criminal justice funnel is beneficial to the maintenance of criminal justice and safety security in the United States, and in what way is it detrimental to maintaining and achieving justice, and in what way might it be detrimental to safety and security in the United States. So let's think critically about it and keep those in mind as we move towards our midterm exam, which is off into the future, but still this is how these slides are used. So thinking about all the places where that narrowing takes place within the criminal justice funnel, what places, when you were learning about it on that last slide, where were you sort of like, hey, wait a second, that seems like a failure. Like we should be able to do better in terms of that, those different decision points within the criminal justice process. So maybe when you learned about the low level of crimes that are reported to police, maybe that was a cause of concern to you. As I noted on the last slide, about half of crimes are never reported to the police. Well, is that a cause for concern? Well, it might be a cause for concern if the reason people don't report crimes to police is because they don't trust the police, that they don't have any confidence in the police's ability to do their job. It also might be a cause for concern if that you think there might be retaliation for reporting crimes to police. Not retaliation from the police, but maybe retaliation from people in your community or in your neighborhood. And maybe it's a little less concerning if people don't report crimes to police because they think that they're sort of low-level crimes. We live in Milwaukee, and we've been victims of crime, some more serious than others. But we've had our porch furniture stolen out of our backyard, and we didn't report that to the police. Maybe we should have, but we didn't because we were like, there's better things that the police should be doing with their time than trying to find my crappy ass, excuse my language, patio furniture. What about the low clearance rate? As we saw on the slide, only about 20% of serious crimes are cleared. In other words, and keep in mind that word cleared means that a perpetrator is arrested, that the person who committed the crime is identified by police and turned over to the prosecutor. That could be a real cause for concern, that low clearance rate. We have to ask ourselves, why is there a low clearance rate? If there's a low clearance rate because we don't fund police enough in order to effectively do their job, that could be a real cause for concern. It could be a cause for concern if nobody wants to help with the police, giving them assistance in terms of information for clearing crimes. So it also could be the type of crimes that aren't cleared, right? Like if you can't find out who stole my porch furniture, not a big deal. But if you can't find the person who murdered my next door neighbor, heaven forbid, that would be a much greater cause for concern. And prosecutorial discretion. We talked about that concept of nolli prosequi, that prosecutors just sometimes say, we're not going to pursue this case. Is that a cause for concern? Again, it could be the reasons why. If it's because the prosecutor thinks that they're going to get pushback publicly, and prosecutors are, at least at the state level, are almost always elected, that's probably not good. But if they really think, look, we'd like to take this person to trial, but we wouldn't feel confident that we'd get a conviction, that is probably saving taxpayer dollars. And so again, depending on the factors that contribute to that funneling, helps us get a better understanding of sort of the impact that it has for criminal justice in the United States. Okay, so we know that most steps in that most offenders don't go through all the steps within the criminal justice process. And the question is why? What are the factors that contribute to that? So let's turn our sights to two major factors. One is called the Courtroom Workgroup, and the other is called the Wedding Cake Model of Justice. And let's start with the Courtroom Workgroup. I think that when most people think about what goes on in the courtroom, and even just thinking about not just the trial, but other aspects of courtroom hearings, like the arraignment and setting the bail, et cetera, et cetera. I think that what comes to mind is sort of the Hollywood or the televisual sort of representation of what happens in a courtroom, and that's a picture from a classic movie, A Few Good Men, right? And even though that has to do with like the military criminal justice system, it's sort of like a really good representation of the adversarial, mythology of what takes place in the courtroom. And so, oftentimes the way the courtroom and the courtroom people who work in the courtroom is portrayed, or the assumptions that we have about it, is that we see it as adversarial, right? That the prosecutor is doing everything in their power in order to bring about justice, and the defense attorney is working mightily and adversarially in order to make sure that their client is not convicted. We get those portrayals all the time in television, and in the movie The Few Good Men is just one example of that. But as is the portrayal of a lot of things on television and in movies, the reality of what goes on in the courtroom is much different than the fictional portrayal in movies and on television. Because the reality is that the process is often cooperative. What goes on in the courtroom, whether it's hearings or a trial itself, is rarely adversarial, but it's oftentimes cooperative. And the members of this courtroom work group, which we'll talk about in more detail in a second, define it and talk about why it ultimately is more cooperative than adversarial, is that the members who work in the courtroom often share the goal of getting an offender through the process as quickly as possible, to avoid delays and to be efficient, not be cooperative, not adversarial. So let's dig in and learn a little bit more about the details of the courtroom work group. So what is the courtroom work group, and who are the members of the courtroom work group? Well, the courtroom work group is primarily the main people who work within the courtroom. And so it's composed of the judge, of the prosecutor, and the defense attorney. But also other court personnel also share the sort of the values and the norms of the work group, whether that's the court clerk or whether it's the bailiff, etc. But the main actors within the courtroom work group are the judge, prosecutor, and the defense attorney. And the thinking about the courtroom work group is that the judge, the prosecutor, and the defense attorney aren't adversaries, but instead they share similar goals, even though they're on sort of different sides, right? I mean, the prosecutor works for the state, the defense attorney is defending their client, the judge is neutral arbitrator, right, in the middle. But the members of the courtroom work group really share goals. And the main goal that they share is that they want to streamline the process of justice as much as possible. Remove delays, avoid trial, use plea bargaining and other trial alternatives to really avoid a trial at all costs, okay? And so the judge and the prosecutor and the defense attorney all sort of share those goals. And there's features of the work group that really kind of facilitate these shared goals and that facilitate this cooperative working together. One is that, we think about prosecutors and defense attorneys as being so different from each other. But really the members of the work group, they have a lot in common. That many of them, they're all lawyers, and that many of them have, gone to the same law school. So if you work in Wisconsin and you're a lawyer, chances are you either went to Marquette or Madison for law school. And so it's very likely that the people that you work with are alumni of yours, or you might have even gone to school together. So you have a lot in common. You also spend a lot of time. A defendant spends a very particular discrete amount of time in the courtroom. But the judge and the prosecutor and the defense attorney that's their workplace. They're in the courtroom day in and day out. And when you go and at the end of the semester and actually visit the court, you're going to see the courtroom work group in action. They know each other. They might even do social things together, right? Their kids might be in the same baseball leagues, yay baseball. And so they really have a lot in common, and they have the same kind of income level and same sort of level of education. So they have a lot more in common with each other than they do with the actual people that they are representing. And they share certain assumptions. One major assumption is that if this individual has been charged with a crime and is, being bound over for trial, chances are that they're guilty. Okay. Now, whether that might not be a fair assumption to make, but it's an assumption that oftentimes the courtroom work group shares with each other. There's certain assumptions regarding the importance of winning a case, and that of course you want to win a case in order to be serve justice. But if you're a prosecutor, you want a winning record. Why? Because a lot of state prosecutors don't make a lot of money, and they're wanting to make a leg up to be able to get into a private firm where they're going to make a lot more money. And the same is true with a defense attorney. The defense attorneys, public defenders in particular, the courtroom is a place for them to get experience, to get known, to maybe enter into prosecution, or maybe to run for public office in the future. So there's some shared assumptions that yes, the courtroom is a place where justice is achieved, but it's also a place where people can hone up their record in order to use it as a stepping stone into a future professional career. There's also a hierarchy of shared norms. So a lot of prosecutors and defense attorneys, they have bosses. So you're an assistant prosecutor, but there's there is the actual district attorney that you work for. And the district attorney is expecting you as an assistant prosecutor to go in there and avoid trial at all costs. And if you're not doing that, then you're not going to get very far in your job. So it's all of these sorts of norms and values and sort of social dynamics that contribute to the shared goals of removing delays, streamlining to avoid trial. There are real benefits to, sorry about that, my dog was just barking. There are real benefits to the courtroom work group. One benefit is that there's a lot of people that end up in court, right? Whether it's preliminary hearing, the arraignment, entering a plea, and then going to trial. There's a lot of overload. The case load is huge. So if everybody went to trial, that would break the back of the criminal justice system. It also benefits those who commit the least serious crimes. One of the shared norms is if you're a chronic offender and you're constantly in the court, then we're going to treat you more seriously. And we're going to treat you more seriously, the courtroom work group is, if it's a serious offense. But for those who have less serious offenses, first-time offenses, there's shared norms to not, to avoid trial, and also to, come up with an alternative besides incarceration. There can be drawbacks, and the drawbacks are that the rights of the criminally accused can be bypassed. You assume everybody's guilty, but that's not fair to those who are not guilty, and they might have pressure to engage in a plea bargain. And that just because you are guilty doesn't mean that you shouldn't afford yourself to the best criminal defense, even if you can't afford it, because you're not proving that you're innocent. The state has to prove that you're guilty, and if the state's not capable of doing that, then that burden is placed on the state. And so there are some definite drawbacks from the courtroom work group as well. Okay, so the other factor that contributes to the funneling in the criminal justice system is the criminal justice wedding cake. And the criminal justice wedding cake was created by the justice historian and scholar Samuel Walker. And he created this as a way of describing the informal criminal justice system that we are talking about. And so, basically based on his research, then he said, look, the informal criminal justice process looks like a wedding cake. And so let me put my little pen on here. If you think about a wedding cake, it's tiered, okay? And so that you have one layer on the bottom that's really big. And then as the tiering goes up, that each layer gets smaller, okay, until you have the very top layer. So that's what a wedding cake looks like. And you're probably like, hey, Professor Hankinson, what does the wedding cake have to do with the informal criminal justice process? Well, let me tell you. And so each of these tiers are different types of cases in the criminal justice system. And so at the very top are what are known as what Samuel Walker referred to as celebrated cases. You'll notice that the first tier is the smallest tier. And that's because celebrated cases happen very infrequently within the criminal justice system. That when you think about celebrated cases, sort of a classic one would be O.J. Simpson, former football player who is charged with killing his wife, Nicole Brown Simpson. That you could even say the Kyle Rittenhouse case might be a celebrated case because it got a lot of attention from the media. And so a celebrated case, Martha Stewart, I think you guys know who Martha Stewart is, that she, was charged and convicted of insider trading. And so celebrated cases don't happen real frequently. They generally deal with somebody that either we know, like O.J. Simpson, or is getting a lot of media attention. And so that's the first tier. The second tier are serious felonies. So these serious felonies are, celebrated cases could not be as serious, right? I mean, like insider trading is serious, but it's not as serious as like multiple homicides, right? But Martha Stewart still, ended up in that celebrated case tier. So the second tier, though, is just straight up serious felonies, right? So serious felonies would be homicide, manslaughter, aggravated assault, serious felonies. Tier 3, so less of those, but higher up. Tier 3 are the less serious felonies. And so a less serious felony might be like negligent manslaughter, could be, car theft, could be a form of assault that's not aggravated. And then on the bottom, less serious crimes, which are known as misdemeanors. So a couple of takeaways from this. One, there's a lot more misdemeanors that take place in the United States than serious felonies. Two, that the wedding cake is that this tells us the amount of attention that the type of crime gets from the criminal justice system. And so celebrated cases get like a lot of attention from the criminal justice system. That in other words, that celebrated cases and serious felonies are more likely to go through all the steps of the criminal justice system than misdemeanors. Misdemeanors are more likely to either be people won't be charged for a misdemeanor, that they are more likely to take a plea bargain, that there might be a diversion. We're going to charge you unless you get some rehab or get some job training, and so they get the lesser amount of attention from the criminal justice system. But celebrated cases, maybe because you want to send an example to other people. This is what happens. We know Martha Stewart. This is what happens if you, engage in insider trading. The likelihood of getting a plea bargain or others in a celebrated case that's less likely to happen because the criminal justice system is going to focus a lot of their attention on that. Okay, so how does the courtroom work group and the criminal justice wedding cake contribute to the funneling? I think you're probably already getting why that it does, but let's just make it clear. So that when it comes to the criminal justice funnel and the courtroom work group, that, since the goals are avoiding trial and getting a case through as quickly as possible, that really helps us understand why the prosecutor may not pursue a case, because they might say, look, if I pursue a case and I take it to trial and it's just basically wasting every time because it's going to result in acquittal, I don't want to go to trial. Nobody wants to go to trial. So that's why we're not going to pursue some cases. It really helps us understand too why there's such a high level of plea agreements. There's an assumption of guilt. There might be pressure placed on people to plead out. and everybody's sort of on board with that. And how the celebrated or how the criminal justice wedding cake contributes to it. It gives us a sense of just the amount of focus and time that the criminal justice system is going to spend on different types of cases. Misdemeanors, maybe likely somebody won't be charged. Misdemeanors, more likely that you're going to get probation, right? But more serious cases and also celebrated cases where we can use those people as an example are much less likely to be funneled out, because there's agreement of those who work in criminal justice that we should spend more time on serious felonies and have them go through all the steps and less time on the misdemeanors. Okay, that's it for this week. So looking forward to next week. We will be doing the second half of chapter 1. So this week is just the first half. And that we're going to be examining the 6 perspectives of of criminal justice. So you'll be learning about the crime control perspective, rehabilitation perspective, due process perspective, etc. And then next week, not this week, but next week will be our first a substantive online discussion, and that you'll be applying those criminal justice perspectives to an online discussion. So that's it for this week. Feel free to read forward in chapter 1 if you're so inclined. This just gives you an idea of what we're going to be doing with that second part of the chapter. All right, thanks a lot for listening, and I'll talk to you again soon.